and welcome to Stowe Talks, a podcast designed to support all those going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. In this podcast, we're going to explore the different options for financial agreements, what a clean break is, what maintenance includes, and how to decide what works best in your case. So this is something that comes up quite often in initial appointment, really. You know, what are we looking for, end goal? And as lawyers, we'll often talk about clean break. So do you want to start us off, Matt, by explaining what a clean break is?
So when you sort out your finances on divorce, you should end up with a court order, which is normally a consent order, doesn't require proceedings. You will have a document which the court approves, and that's going to set out what happens with all the assets, the house, and so on. And you have two options for how that kind of ends. You can either have a clean break. There will be a clean break at some point. You can either have an immediate clean break or a delayed clean break. And what a clean break is, basically it means that when you have a clean break, you have no claims against the other party as a result of the marriage. So there's two types of clean break. There's a capital clean break and an income clean break. And almost always, other than pretty rare circumstances that we won't cover today, there will be an immediate capital clean break. So once you've dealt with the house and the pension and the savings, there'll be no further claims against capital. Capital is sort of one bite at the cherry. So your order will say there's a clean break as to capital, and you can't go after further property adjustment orders or lump sums or whatever. With income, there's usually a clean break in most cases, but in some cases there's not. And when there isn't, that's because there'll be a spousal maintenance order. So you will either say there's a clean break as to income and capital, or just to capital, and then the income will roll on for whatever term of spousal maintenance until the clean break kicks in, and at which point you can't make any further claims. So that's what we mean when we talk about a clean break, because loads of people come into an initial meeting and saying, I want my clean break order. And then you go through it and it looks like there might be some maintenance payable, and you're like, well, that's not quite what's likely to happen here. And they go, oh, okay, well, I just kind of meant order. I'm all right with paying maintenance, or perhaps not so all right with paying maintenance, as the case may be. So, Lisa, maintenance, do you want to run through the principles of when is maintenance going to be payable? Because I think there's a lot of people who come in and say, well, hang on, a wife might come to me and say, well, my income's this and my husband's income's 3 times mine, so therefore I should get maintenance. I mean, is that right?
There's no specific calculation on maintenance, and it's not about ensuring that you both have equal incomes. There was talk at one point, in fact, somebody mentioned it the other day, about 30%.
Yeah.
30% is, that's what we're going to look at for income claims. There is no black and white calculation for income claims. I suppose the first thing to say is there's two types of maintenance. So we've got child maintenance and then we've got spousal maintenance. Now, with child maintenance payments, firstly, child maintenance will always be payable if there's a dependent child. Child maintenance is dealt with by the Child Maintenance Service. It can go into a consent order, a financial order in divorce proceedings, but only if that's agreed, or if the paying parent's income is over the CMS threshold and they've done a maximum calculation. So if child maintenance goes into the order, you can still get a clean break. That doesn't prevent an income clean break if there's no spousal maintenance. And the child maintenance, if it's in an order, the order takes precedence for 12 months, but after 12 months, either parent can then apply to the Child Maintenance Service and their calculation will then overtake it effectively. So that's child maintenance. When we look at spousal maintenance, then we're very much looking at needs. So the starting point is for both parties to prepare a schedule of their income and outgoings. And what we're looking at is, are both parties able to meet their own needs? So first of all, if both parties from their own income can meet their own outgoings, then there will be no spousal maintenance claims, and you would be looking at an immediate clean break for maintenance. However, if one party can't meet their outgoings, so perhaps that party is either on a significantly lower income, or perhaps they gave up work during the marriage to care for the children and therefore they don't have an earning capacity at the moment, that's where the maintenance claim will effectively come in. So what we're looking at is what's their shortfall. So what's the receiving party's shortfall each month? And then we look at the paying party or the higher earner and we look at what their surplus is. Equally, if that party doesn't have a surplus, then there can't be a maintenance claim. So there has to be both a deficit for one party and a surplus for the other party for that maintenance claim to come in. And then we're looking at what's reasonable as far as term is concerned. So going back 20 years, it wasn't uncommon to have joint lives maintenance orders and maintenance orders that went on for quite a significant number of years. We've definitely moved away from that now. The courts are definitely moving towards taking both parties towards independence and having them sort of financially independent as soon as possible. So we're looking at actually how quickly can we do that? And it may be, for example, that you've got somebody that's in their 30s or 40s who needs to requalify to be able to maximise their earning capacity, or they need to go back to school, or they need to do requalification, and that's going to take 5 years. So it may be that we look at maintenance payments to cover that 5-year period on the basis that at the end of that, they would then be independent and able to cover that themselves. And that's when the clean break would then kick in.
Yeah, I think that's all absolutely true and really helpful. The important point is that someone's earning capacity isn't a matrimonial asset to be shared. It's a case on that called Waggett, where the court said, look, that's not a share. You can't approach the principle of sharing someone's future income. It's only to meet needs. And needs for income are pretty harsh because the law actually says there is a statutory steer to a clean break. The court has to achieve a clean break where it can, which I think is best for the parties because you want your finances to be separate and you go on your merry way if you can. But they will only consider a spousal maintenance order where to not have one would leave the party with the lesser income in a position of undue hardship. So that's the phrase, undue hardship, in air quotes, which suggests that a bit of hardship's all right. You know, it's not giving someone loads and loads of money. It is the sort of bare minimum to get by. So I think that's part of the reason why there's been certainly a swing away from maintenance payments. I mean, you're absolutely right. When was the last time you did a joint lives order for maintenance, Lisa? You remember one? I've maybe done one or two in my career and not for years.
I've dealt with variation of joint lives maintenance orders.
Same.
So they've come back up and we've changed those. No, the furthest that they've gone that I've dealt with would be to retirement, to the maintenance, because we equalise pensions afterwards and therefore it's only fair. Because
pension sharing is a lot more common than it used to, you run the maintenance because that's when the income kicks in.
Yeah.
And that's a really important point on variation. The thing about maintenance is that maintenance is always variable. Because there isn't a clean break, so you haven't shut off claims on income, the maintenance remains variable until there's a clean break. If you have a clean break, you can't, other than the rarest of circumstances, go back and amend an order. It's done. That's it for the vast majority of situations. But maintenance is always variable. It's variable for quantum and it's variable for term. So in terms of quantum, it can go both ways. So a receiving party can come back and say, actually, my needs aren't being met by the amount that I've received, and the paying party has a greater surplus, so I can increase my income. Now, I've never actually seen that in practice. I think it's incredibly difficult to increase income. I think you would need to show some drastic change in circumstances, probably involving ill health, and it would need to be relatively close to the marriage because the court's looking at needs in maintenance cases is about relationship-generated needs. So you can't necessarily say 15 years later, oh, something's gone wrong, I need my ex-husband to bail me out. It's very hard to do that. You can be very downwards and you can say, look, my ex-spouse is now retired, I've been paying maintenance for 10 years, it's on the joint lives order, I'm about to hit retirement, I need to save some money for my retirement and my income's reduced because I've had to go part-time because I've got health reasons. Or maybe, I've lost my job and I don't have any income to pay maintenance from. And that's when you can vary it. Either change the quantum and reduce it or bring the term to an end. You can terminate the maintenance obligations. Equally, you can extend the maintenance term unless you have what's called a Section 28(1)(a) bar, which prevents an application to extend the term. So there's quite a lot that goes into these maintenance applications. I think it's probably one of the trickier areas because it's less, when you're looking at matrimonial assets, you start with the formula of add up and divide by 2, and then you move away from that. Child maintenance, as you said, Lisa, unless someone's earning over 156 grand or there's some international elements usually, that is literally a formula. And for most people, go on the Child Maintenance Service website, play about with the formula, get the numbers. You may as well do that rather than paying a lawyer to do the same thing. But maintenance is a lot more subjective because, if I'm claiming maintenance off Lisa, I'm going to produce a budget which says that I need to spend X amount per month on my beauty treatments, my manis, my pedis, lip filler, Botox. These looks don't come for free, Lisa. You're going to have to pony up for that. So I want $5,000 a month off you. I mean, what are you saying to that when you see my income schedule and I'm like...
I'm taking a red pen to it, Matt, is what I'm doing to it.
Yeah.
I'm taking a red pen to it and I'm going to cross a load of that stuff out.
Presumably because you think I'm pretty enough, right?
No comment.
Yeah, fair.
Yeah, so usually you'll have two schedules that are significantly apart. And ultimately, if the parties can't agree, it'll be a judge that will go through those schedules and the judge will make a decision as to what they believe are the right figures for these things. So it's also really risky if you go to a judge because every single judge that you could go before will probably have a different idea based on their lived experiences as to what a reasonable income need is. So it's hugely risky in that respect as well. To get a clean break, though, let's say there is a maintenance claim, but you want that clean break. So it's not uncommon for the higher earner to say, look, I understand that there needs to be a gap that needs to be plugged, but I really want a clean break. I don't want to have to worry about further maintenance claims being made, variation applications, etc. further down the line. I really want a clean break now. They can capitalise. Do you want to talk us through that, Matt?
Yeah, sure. So you can buy off a clean break by way of capitalising it, and is effectively converting that maintenance sum into a lump sum that the party can receive now. So the amount of that will depend on how the maintenance has been calculated. So let's say you work out that there is a shortfall of £1,000 a month, and that needs to be paid for 3 years. Let's say a 3-year term. Okay, so that is £12,000 a year, so £36,000. That is the amount that I need to get from Lisa to pay for all my beauty treatments in this scenario, which never would happen. But there we go. So I need an extra £36,000. So I either get £1,000 a month or I get £36,000 right now. So Lisa might say to me, look, I'll give you 30 grand right now because you'll get a bit of investment return on that, accelerated receipt. The other reason why these capitalised lump sums are often discounted a bit because of remarriage. Because if I have a maintenance order and Lisa's paying me £1,000 a month, that would terminate if I remarried. So nobody ever remarries. Because why would you? Because you're giving up money. But if I get the lump sum, I can remarry. So you might say, well, I'm not giving you full amount because if I give you 36 grand and you get remarried in 2 months, then I've just given you 34 grand I didn't need to do. So there's a bit of a discount sometimes for that. So that's one way of doing it. If you have a joint lives order, there is a formula called the Duxbury formula, which is from the case of Mr. and Mrs. Duxbury from the 90s, which basically looks at a whole series of very complicated factors. And there's just been some refinements made to this fairly recently. So we're recording this in July 2025. In the past 6 months, I think, there's been a reworking of the Duxbury formula from the Duxbury Working Group. And what that looks at is basic assumptions about how much income can be generated from capital, relying on investment returns, moderate risk, discounting a little bit for the possibility of death. Death will terminate a maintenance order. So, if I have a maintenance order and Lisa dies in a couple of months, then my maintenance payments terminate because there's no one to pay me them. So there's a Duxbury formula that works out, and it's a fairly complex formula. You need to speak to a lawyer who can do the sums for you on that. The other way of looking at it, though, and this is quite a common way of looking at it, is rather than taking the hard and fast numerical approach of going, okay, £1,000 a month for 3 years equals 36 grand. Because it's quite hard to agree often a lot of the time on what that sum should be. I might say it should be £1,000, you might say it should be 250 quid a month, and that becomes a great difference over that period of time. You might have a look at someone's budget and say, well, actually, on the share of capital, I need a mortgage of 100 grand, and that's going to cost me however much it's going to cost a month. But if I didn't need that mortgage, or I needed a smaller mortgage, let's say it's a 50 grand mortgage that I would need, a smallish mortgage, if I didn't need that mortgage and didn't have to make the repayments on that mortgage, I'd be able to fit my own budget. So actually, you say, we'll depart from equality on the capital so that I can buy mortgage free. Lisa, with her bigger income, can survive a higher mortgage payment, it's no problem. But that means that Lisa gets a clean break because my need for the extra money goes away. So that's another way. It's a less probably forensic mathematical approach, but quite often I think that's the solution that can be arrived at, which what you're not doing is sharing someone's future income. I'm not saying I've got a right to share Lisa's income, but my needs, my housing needs are met by having the house, and my income needs are met by not having to pay a mortgage on the house. I mean, that's quite a common sort of approach, isn't it?
Yeah, it is. And it will often mean a slight move in the capital from 50-50. But I think people are able to stomach that because they know that they're getting that clean break.
Yeah.
And it takes away the risk, if you like, of maintenance orders in the future.
A little word, unmarried partners as well. Clean break orders don't apply from unmarried partners. I mean, what's the position there, Lisa?
So, with unmarried partners, there is no spousal maintenance. So you haven't kind of signed up, if you like, in the same way that you do with a divorce. And therefore, there aren't any spousal maintenance claims. So the claims between unmarried partners are very much in the property laws and the capital if they own property and things jointly together. But there wouldn't be any spousal maintenance claims. There are claims that can be made in relation to children. So child maintenance is exactly the same. And there's also claims that can be made if you've got children together under Schedule 1 of the Children Act, which is in relation to, if there are further income needs specific to the children on top of child maintenance, then you would be able to make those claims there. But it's probably not something we want to delve into too deeply in this podcast.
I guess as a final point is a little warning. We normally end with happy stuff on this, but I'm going to end with a little warning, which is the story of what happens if you don't get your clean break order. Because if you don't get an order and don't have a clean break, claims remain open indefinitely. There's no long stop date. The case of White and Vince is a very famous one, which kind of established that in the law in England and Wales. And in that situation, the parties separated in the early 90s. I think they lived in a caravan. They had essentially nothing and they separated and they didn't get an order. So what they should have done, what everyone should do, is get a clean break order, which says there's no payments to anything, there's no lump sums, but you're both clean break and move on your way. That didn't happen. And I get why. Like, you just think you've got nothing, so why would you? Mr. Vince then went on and founded a tremendously successful green energy company and is worth a lot of money. And then Mrs. White came back years later and saying, well, I have these needs. And it went to, I want to say, the Court of Appeal. I'm pretty sure it was a Court of Appeal case, not a Supreme Court case, but I may be wrong on that. And the court said, Mr. Vince says, look, you can't bring these claims. It's too long. You just can't bring it. And he lost. Because the court said there's nothing that prevents claims being made at some point in the future. So go away and sort it out. And as I understand it, they did. There was no further reported case as to what was actually awarded in that. Now, that's not to say that Mrs. White would have ended up with 50% of the assets at that point in time, because the judgment says, look, it's not going to be a sharing case. Clearly not. But there are needs in this case, and those needs do relate to the relationship in some way, shape or form. So there would have been an award. So if you don't have a clean break order, claims remain open, and you never know. You might look out and win the lottery and then realise you're not so lucky because there are still needs that can be met from those resources, or you have a pay rise or an inheritance or whatever. So always get an order following your divorce, sorting out the finances, even if you have no assets at that particular point in time to deal with.
So that's it for this episode of Stow Talks. Thanks for listening. If you would like more information on our podcast, head over to stowtalks.co.uk and please rate, like, share and review this podcast where you can.